Representative Tumlin, there you are. Yeah, I need to turn your mic on too. That's where. Yeah, if that's good for you, it's good for us. Is your mic on now?
Yes, sir.
Okay.
Mr. Chairman, members of the committee, I appreciate y'all being here at such an early time on such a cold day, and I'll try to make this brief. I'd like to give, with your permission, just an overview of the facts of this matter, and then introduce Amy Maxwell and Buddy Darden to kind of supplement what I say. Amy's with the Georgia Innocent Project, and Buddy Darden's with the law firm of Long Aldridge, and a constituent, my former congressman, and a good friend, but he's very aware of this particular matter I'm bringing before you. Just imagine in April of 1985, there were 2 violent rapes in the community, of the then community, Sandy Springs, and I think the community was pretty well in alert looking for the possible perpetrator. And the witness had gone through this trauma. The rape victim had worked with the police and come up with a police sketch, a composite, if you may. And then about 3 weeks after the first rape, there were some young men in a car, and they were pulled over for a minor traffic violation. You know, they weren't pursuing a crime. There was no outstanding warrant, but there were several young men in a car. And the passenger in this car was Mr. Pete Williams, and with a flashlight in his face at about 2 or 3 in the morning, he looked like the composite, and he was taken into custody, and his life changed forever. By September of 1985, based on both witnesses of the 2 different crimes, he was sentenced in September 1985 for 45 years. He went in this Mr. Williams, Pete Williams, went in the jail, and he was like the rest of us would be, being innocent of a crime. And he was bitter, distraught, but he found his peace with God. He got his GED, and he basically got his life straight as well as you could to be incarcerated for a crime that he had not done. In the late 1990s, 1997, 1998, he had served well enough as a prisoner that he was offered parole, and but it was conditional. It was conditional upon him signing a statement that he was a sexual offender. His pride and his integrity just would not let him do it, so he wasn't a sexual offender, and he just wouldn't sign it, so parole ended up being denied. By 2006, he read an article in the Georgia Innocent Project, and he contacted them. They reviewed his case, and as most lawyers would tell you, there's not a person in a jail that's not guilty. You know, so they hear a lot of claims, but they liked what they saw, and they pursued it, and they found a motion. You can't, under Georgia law, forget the actual site of what the law is, but you can reopen a case for the purposes of DNA, and there's very few. They want an appeal, but you can't open it for DNA, which was not available in 1985. So from there must be some kind of destiny in this. All the evidence in Fulton County was still available, and they were able to get to it. And with an FBI-approved DNA test, it was conclusive that he was not even there, much less the perpetrator of the crime. So after 20 years, the Georgia Innocent Project took to District Attorney Paul Howard in Fulton County. The evidence was so conclusive, he filed a motion for a new trial, and within 4 days, he was set free. They filed, after he filed the motion and the release, then he was a free man. And then now there's already a man under indictment that committed the crime. Part of the evidence that came in besides the DNA, there were, between the April and September after he'd been convicted, there were 3 other rapes with the same MO that, they just kind of ignored. So it was obviously, it could have been somebody else, but his representation just did not bring that across. So from there, he's back. He's gainfully employed. We'd invite him to come down today, but he's gainfully employed. Obviously, when you come out of prison, you have no savings, no home, and you have to rebuild your life. But he's at work today and could not get off. But I think, the facts are, I think, what this committee would like to look at first anyway. So when you have a claim against the state, it's basically in lieu of a lawsuit. There was never any threat, but because we do have a procedure, because we have sovereign immunity with some exceptions to it, and it goes before the Claims Advisory Board. And in this claim, and the state representative has to sign it, and from what I saw, I was glad to be a party to it. And they present it, and part of the claim deals with, it's investigated by the Department of Corrections, and they gave a favorable look to it. And then the lost wages, the lost opportunities, lost retirement, lost Social Security benefits, health and all became to be $1,179,000. So this bill asked for $1.2 million, and as part of the Department of Corrections recommendations, they say they looked at around $1.1 million, or $1,100,000, and said, but also, or we take any amount consistent with the past. And last year, Mr. Harrison got $1 million 2 years ago, and Mr. Clark, and both of these are a comparable amount of times, was $1.2 million. So this claim is for $1.2 million. And obviously, it's the tort things that we're seeking today: loss of liberty, pursuit of happiness. All those things were taken away from them. Just imagine if you were, I'm long past my 20s and 30s and 40s, but I would hate to have lost them. And I think that's an easy thing to identify. And I'd like to point out this claim is in full settlement. It is a release. It's $100,000 the first year, and then $50,000 a year for the remaining 20 years. And it's consistent with the past, and just trying to think. Well, I think the questions will probably bring out most other testimony, but I think I hope I've laid it out where you can at least start to consider it.
Thank you, Representative Thomas. Thank you for a very thorough presentation. Appreciate that. Do we have any questions, Representative Tumlin, from members of the subcommittee? I don't see any questions. I do have one question. It's actually a comment, I guess. Last year, the gentleman last year, whose name I cannot recall now, but you had referred to him, that $1.2 million, that sum came up because they'd asked for $1 million for compensation for the time he was in prison, but then there was also the $200,000, I think, was in addition because of some kind of medical issue that had arisen while he was in prison, I think. In fact, I'm pretty sure of that. I don't know if anybody on those. So it would seem that was the reason. I think the previous year, or one of the previous Representative Stuckey had him. I think that represented him. I think that was $1 million. So I think that $200,000 that you said was based on past compensation resolutions and these kinds of matters was based on a different issue. However, I'll leave that up to the members of the subcommittee. Any questions? Is there anybody else who wants to speak in favor of this? Yes. Former Congressman Darden.
Yes, Buddy Darden, and I'm proud to say a former member of the General Assembly. And it's good to be here this morning to you and members of the subcommittee. My law firm, McKenna Long and Aldridge, in effect, adopted Mr. Williams in the early stages of working with the Georgia Innocence Project. And I can't say enough about Amy Maxwell and the Georgia Innocence Project and what they have accomplished in this state to bring about justice. But we are here, and I want to point this out to the committee, is that I am here pro bono. We're charging no fee. We're donating our time because we fervently believe that justice should be done here, and we're assisting, and we want to thank Representative Stuckey and as well as the Georgia Innocence Project. What I want to point out to the committee, again in the strongest possible terms, that here's a man who could have been released in 1998, but because he believed in what he was doing, because he maintained his innocent state in prison almost another 10 years, just because he hoped one day that this day would come. So he's go back to his job. He's not mad at anybody. He's found peace with himself, and he's just asking now for justice. And I don't think the amount of money that's being asked is unreasonable at all, and we do thank Representative Tumlin for bringing this forward. You might say, well, what's Steve Tumlin doing handling this bill? Well, I want to thank him. He is my representative. I am his constituent, and he filed this at my request. And I want to thank him profusely for taking this action. Thank you.
Mr. Darden, I don't see any questions. Any questions of former Congressman, former Representative Darden? I don't. Well, there is one. Yes, if you don't mind taking it.
Ms. Howson, be delighted to have you.
Well, I am just sort of appalled that they would keep somebody in 10 years because they wouldn't admit they were guilty. Is that usually the standard procedure? If you don't admit you're guilty, you don't get out?
That's pretty much the case because, as you know, parole is a matter of grace. It's not a matter of right. And they can make you serve every
I know they can make you, but you have to admit you're guilty.
That is pretty much standard operating procedure. Yes, ma'am.
Thank you.
Okay. Any further questions from the subcommittee? We have. I want to make sure. Is there anybody else want to speak in favor? We do have. If you'll come to the mic, please.
Yes, you have to accept responsibility. That's what the parole wants you to do. I wanted to just clear up just a couple of things. The $1.2 million for Robert Clark, actually I think that the initial request was something like 1.4. And that the 200,000 recognized that he needed psychological services quickly. We had not been able to find, we'd found volunteers for pretty much everything except the psychological services. So that allowed two annuities. That allowed the $1 million annuity to kick in. He got $100,000 up front, and then it's kicked in after that. And the medical one kicked in right away. Mr. Williams, while not getting a diagnosis, is from my complete lay opinion, is suffering from serious post-traumatic stress. Unfortunately, again, we have not been able to find him a volunteer psychologist. So while they are in very much the same position, that's the situation with the $1.2 million. Also, I'd like to point out that Mr. Darden, talked about the case. Mr. Williams was in no way involved in this case, except that he happened to match the composite drawing. He was arrested after 2 crimes. The crimes kept happening. The exact same crime kept happening 3 other times. Someone else was arrested and convicted of those other 3 crimes, Mr. George Wicker. When they tested the DNA, Mr. Wicker was actually guilty of the crimes that Pete Williams had been in prison for. So the real perpetrator is in Fulton County right now under indictment. After all these years. So the whole case has kind of come to that end. So if you have any questions about Mr. Williams or the case, I can help you.
I don't see any. There is a question. Yes, Chairman Mills. Okay, thank you. Thank you. Maybe something we need to look into.
Can I comment briefly on that?
Yes, absolutely.
Mr. Chairman, if you look at the overall
If you would come to the mic. The only reason I ask you that, this has been webcast and they can't hear if you don't.
I'm putting on my district attorney hat now. I was privileged to serve as the Cobb County District Attorney and Assistant DA before that, back in the 70s. And generally speaking, insofar as liability is concerned, legal liability probably rests in federal court on these local jurisdictions, probably rather than the state. It's kind of a murky situation here. And this legislative solution pretty much solves this, because otherwise you might have rather enormous judgments against various jurisdictions where this occurred. This is not unique, by the way, to Atlanta and Fulton County. This happens around, and it's been determined that this is probably the best way to handle it. We've been proceeding on an individual basis. Now, I believe Representative Stuckey, and she can probably address this issue, tried to pass a bill several years ago providing for a formula and for various ways to do this so that we didn't have to do individual bills. But since that bill did not pass, it's pretty much up on a case-by-case basis. And I don't see any, without the adoption of legislation in this area, I don't see any way to do it other than as we're doing it now. Is that essentially correct, Representative Stuckey?
Thank you, members of the committee, for considering this. I'm basically here today just to be as a resource because I have been working on this issue. I did handle Clarence Harrison's compensation. He was awarded $1 million several years ago. We had actually initially asked for $1.2 million and had documented why 1.2 was appropriate, but we were happy to get the $1 million. But with regards to the liability for the individual district attorney involved, or perhaps the investigator, police officer, whoever might have been at fault, that's an issue that's been raised repeatedly. There's a couple of problems with that. One is liability is not always easily established in these cases, and every single one of the exoneration cases in Georgia, there have been 7, was based on faulty eyewitness identification. So do you go sue the victim of a rape who, with all best intents, made the wrong identification? I mean, that really is who is at fault in these cases. And I don't blame those victims. Human memory is fallible. We make mistakes. When you are attacked and under a stressful situation, in the Clarence Harrison case, the victim was attacked from behind early in the morning. She didn't get a good look at her assailant. And unfortunately, she picked the wrong guy. So do we go after this poor woman 17 years later and tell her she ought to be paying Clarence Harrison several $1 million for making that wrongful ID? Do we fault the district attorney for following up on that identification? I think everybody was doing their job to the best of their abilities. If there is a case where there was clearly some wrongful conduct, and there have been cases like that, and I'm not faulting prosecutors, but there have been cases where there has been wrongdoing found. And I actually have a chart, I'm happy to share this with you, of some of the lawsuits that have been filed on behalf of persons who are wrongfully convicted all over the country. And we're looking, I'm just giving you an example. North Dakota, a man served 4 years wrongfully. He was given $9 million by a jury verdict. A man in California served 3.23 years and was awarded $7 million. So when these cases go to a jury, we're looking at huge verdicts. And the bottom line is, does the county pay for all that? We fund, the state funds the district attorneys. The state funds the indigent defense system. So the money is going to come from us eventually, and if we put this to a lawsuit, we're looking at millions of dollars, bless you. And this is in Fulton County. I don't know how many of y'all are familiar with the Fulton County court system, but they tend to have juries that are favorable to this type of case. And I think if Mr. Clark's case, I'm not Mr. Clark, I'm sorry, I'm getting my persons wrong, Pete Williams, if his case was to go to a jury in Fulton County, he served 21 years? 21 years. I think he would get in excess, well in excess of $1 million. What's in it for him to settle through the state? In essence, this is a settlement. This is a waiver of any lawsuit. He gets his money right away. Frankly, he needs it. He's been out of society for 21 years. And also, he doesn't have to, we don't have to go through the time and the expense of a lawsuit. Any lawsuit would be appealed. We all know it's a lengthy process. This is the process that has been set up by the state to handle these types of matters. And I really think it's in everyone's best interest. I think it'd be great to be able to find who's ultimately at fault and get the money out of them. But the reality is, even if we did get a verdict against some poor victim, they probably couldn't pay. They couldn't collect. So it's an imperfect system, but I think it's the best system we have. It's a process that has been set up. And I will just comment briefly on model compensation. When I appeared before this subcommittee several years ago, several of the members said, well, we've been seeing these cases. We'll probably see more, and we have, subsequent to Mr. Harrison. Is there some formula we can look at so every case we kind of have an idea of how much we should be awarding? So I was happy to follow up on that. I researched some 21 states that have model compensation bills and came up with a formula that I thought was fair, and I presented that in a model compensation bill. And the speaker opposed it. I respect that. He said these should be on a case-by-case basis. So the bill didn't move because of that, but I'm happy to let y'all look at that bill just to get some guidance. But I respect a case-by-case basis. I think is fair because every case is different. So I hope that helps shed some light on the situation. I'm happy to make a copy of these verdicts. I think you'd be pretty amazed at some of the verdicts that are coming out. Here's one, 14 years, $14 million. So if you apply that $1 million a year, we'd be looking for $21 million for Mr. Williams. So I think this is a fair system.
Thank you, Representative.
Thank
Stuckey.
you.
We appreciate it. There were a couple of questions. I don't know if they're directed to anybody in particular. Chairman Mills, did you? Okay, you didn't. And I think. Let's see. Chairman Hill, did you have a question?
Yes, or a comment to follow up, because I concur with Chairman Mills on the concept. And this is an instance, I think, where what Chairman Mills believes that perhaps a local jurisdiction might want to share. We're not talking a lawsuit. We're talking maybe some ability of the state to go back to a local jurisdiction where somehow the investigators and prosecutors ignored that there were virtually identical crimes in the identical area going on. To me, that shows that there was some lack of follow-up in the local jurisdiction. It appears, and of course there's always circumstances that we're not aware of, but it appears based on the information we were presented that there should have been some additional follow-up, and perhaps it's the local jurisdiction that did this might have looked at this a little bit further when you're having the same kind of crimes in the same area in the same manner going on, and they should share. So perhaps we might want to look at, and this is certainly not the year nor the time of the year to do it, but in the future that we might want to look at legislation that would allow us to go back to the local jurisdiction where we believe that they have some sort of culpability or liability in this, because and maybe some of them even have more blatant liability, but this appears to be fairly blatant in my mind. So we'd look at that. Thank you very much.
Thank you. Did you have any comments?
No, I'm happy to look into that. That had to be in conjunction with the Secretary of State's office since they run this compensation panel. I think if such a bill were introduced, we'd have the opposition of the Prosecuting Attorneys Council, and having introduced bills that they don't like, I know that can sometimes be insurmountable. But I'm happy to look at that.
Thank you, Representative Stuckey. Anyone else care to speak on this for in any manner whatsoever? Apparently not. We have before us House Resolution 1078. It's Legislative Council 380510 is the addition. And what is the pleasure of the subcommittee? Okay, we have a motion to approve House Resolution 1078 and send it on to the full committee with a due pass recommendation. We have a second.
Mr. Chairman, I requested I pushed my button before the motion.
Okay. What is your button?
And now that
are you on 24?
I'm on 24.
What do you want to be recognized for?
Excuse me, and it may be inappropriate now that the motion is made, but I'll leave that to the chair. I was going to recommend that this be amended to $1 million, even to be in accordance with the other awards, and to have that consistent. While there was a mention of perhaps some potential medical problems, they've not been documented here as they have been in past cases. So to be consistent with what we've done in the past, with all due respect to the instances and the gentleman involved, I would still recommend that we amend this or make it by substitute to an even $1 million.
Okay, I'm going to recognize you for that motion. You had your button pushed before the motion was made, so we're working on. Okay, we have a motion withdrawal. Motion, whatever that would be. Okay. So we would be working to on the motion to perfect this particular resolution, is there a second to change the 1 million or 1.2 on line 6 of page 2 to 1 million? Is there a second for that? The motion.
Mr. Chairman, we can't give enough money
Okay.
to restore any of these people. We can't, in my estimation, we can't give enough money, period. But Chairman Hill raises a valid point in that, as I remember right, wasn't it hepatitis or? It was a serious illness that he would forever have, and I think the point is that Chairman Hill is making is that do we give someone the same exact amount of compensation that doesn't have a lifetime illness? Of course, who can? I understand he'll have psychological forever. We could talk about that forever too. I'm struggling with that. I'm kind of just voicing my own thoughts here.
We have a motion to amend a committee substitute to House Resolution 1078. Is there a second to the motion by Chairman Hill?
I'll second.
There is a second. All in favor say. Is there any discussion amongst the members of the subcommittee?
I'll just mention I concur with Chairman Mills. There's no amount of money. I would not trade 1 million, 2 million, 3 million, 5 million for 20 years or 21 years incarceration. But what I am looking at is to try and make this consistency. We do not have a formula, but I think this committee is charged with trying to establish some sort of consistency with the circumstances and without the health instance of the hepatitis in the past case. I desire to be consistent, and that's the purpose of my motion.
Okay.
It has nothing to do to denigrate the circumstances of this gentleman.
Okay, we're in discussion. We have a question from Representative Hill, Cecily Hill.
Mental illness is a very serious illness too that'll follow him the rest of his life, and I think if I had been locked up for 22 years for something I didn't do, it would be a tremendous stress on me to deal with that one, even once I was let out. So I think $200,000 is a very reasonable amount to take care of that, because has anyone checked the hourly time for psychologists and psychiatrists of late? It's expensive, and he's going to need good care.
Okay, let's just direct it through the chairman, if you would. We need to move on.
That's it.
Okay. Chairman Roger Williams.
I just want to comment. I think this case has been thoroughly discussed, and I think it's not something we just drew out of the air. It's been well documented. It was the recommendation of the Department of Corrections that this amount be paid, and I think it's due. And at the proper time, I'll make a motion again to do pass on this piece of legislation.
A second.
Okay, thank you. All right, we do have a motion. All in favor of this motion by Chairman Calvin Hill? All in favor say aye. I tell you, well, all in favor, raise your hand, your right hand. All opposed? We have okay. It fails 3-2. All right. On the is there a motion now on the House Resolution 1078? Okay, House Resolution 1078. It is LC 380510. No substitute was developed. We have a motion. Do we have a second?
Second.
All in favor say aye. Aye. Any opposed say no. This motion does pass as approved and sent on to the full committee with due pass recommendation. Thank you very much.
Can I make one brief comment?
Absolutely.
With regards
If you would come to the mic, though.
I think Representative Hill makes a good point, and that about the consistency of the judgments, and that was my effort in the model compensation resolution. I'll just say, if it gives you any comfort, Clarence Harrison, whose case I worked on, he was awarded $1 million. He served 17 years, and this case is 21 years. So I think that does justify the additional $200,000 in this case. That's my one comment.
Thank you. Thank all of you for coming. Thank you very much. Good to see you today.
Thank you.